Morning. New to doing these webinars, so please bear with me from a technical point of view, but I can see we've got quite a number of attendees in now. There may be some more people to join, but we might as well get started. So welcome everybody, welcome to this Forbes Solicitors SIPP and SSAS webinar. We're focusing on issues relating to COVID-19, but we're also focusing on some topical issues that are currently affecting the sector. There's been quite an influx of recent case law on legislation that obviously we're all aware of, and that's something that we're going to pick up in the second part of this webinar. Just get started with a couple of introductions. For those of you that don't know, I'm Adam Bromley. I'm a partner. I'm the head of property and SIPP and SSAS group at Forbes Solicitors. I'm joined today by Mahassan Mahmood. Mahassan, just some good news, recently promoted to associate, so there's some good news for Mahassan there, and he is also a specialist in the SIPP and SSAS sector within the commercial property team, and I know that a number of people on this webinar work very closely with Mahassan. I also have another of my colleagues on today, Laura Hallett-Lee. Laura is one of our property litigation specialists. Laura isn't contributing to the actual slides and presentation, but we thought it would be very useful to have Laura on as a panelist as well, to answer any litigation specific points, especially as we discuss the case law later on. So we've got myself, Mahassan, and Laura on the call. So just a bit of housekeeping from a questions point of view. We have had some questions sent in advance by a few people who are attending, so thank you very much for those. We will try and pick those up as we go along at the relevant points of the presentation, so they should come up naturally and we'll cover those off. As we go along, if anybody does have any questions that they want to ask, then there is a chat box function at the bottom. If we can please just use that to raise the questions. We'll try and pick those up at the end. That's what we're going to try and do. But if there are any questions that are particularly relevant to anything that we're talking about as we go along, then we'll just cover them off as we go. But please do interact. If you think of anything that you want to ask, anything you want to delve a bit further into, please flag them up and we'll cover them off at the end in a Q&A session. And obviously, if we can't get to them all in the detail we would like to, then we can contact people after this webinar. So from a running order point of view, I will be handing over very shortly to Mahassan to pick up on the first topic of the impact of COVID, some of the delays that we've seen, and we'll lead on to talking about electronic signatures, how they're being used and what might be the position in the future. I will then come back on to pick up the point about rent suspensions, rent holidays. Within there, I'll pick up a little bit about valuations, and I'll also talk about the current position in relation to enforcement. And then I will hand back to Mahassan. So for the second part of the webinar, which we'll hopefully get to by around 10:30, where we'll pick up the Adams and Carey recent ruling that I know everybody's very, very interested in, and also the Sippchoice ruling. So two big cases that have come to decisions recently that we'll pick up on at the end, and I'm sure that will prompt some discussion from the attendees. So that's enough with the introductions. I will hand over to Mahassan now to get us started by talking about the impact of COVID-19 on property transactions. Thanks, Mahassan.
Thanks, Adam. Hi, everyone. So I'll start with, as Adam mentioned, just to discuss the impact of COVID-19 on property transactions generally. And to begin with, what I would say is it's no secret that some transactions, from property transactions, have been either delayed or aborted due to the impact of COVID-19 and the lockdown restrictions as well. Clients obviously are a bit more hesitant to proceed with transactions, particularly where there's premises that have been closed down temporarily due to COVID-19, and would prefer to wait until things have settled a bit more. So it's more of a commercial issue rather than a legal one. But obviously, as the lockdown restrictions are being eased slowly over time, there are cases are beginning to move forward as well, and we are seeing, particularly over recent weeks, matters that were originally suspended are being picked up again. There is some good news on that front. But generally speaking, again, from a legal point of view and a conveyancing point of view, there have been law firms and other professional services companies such as surveyors and agents since the lockdown restrictions were announced, who have been working under either reduced hours or just closed completely due to the impact of COVID-19. Others have been open, but given the nature of the conveyancing transactions, obviously all parties need to be actively involved and open for things to move forward, and that has caused delays on some transactions. And it just ultimately depends. It's all obviously ultimately case-by-case basis. Some firms have remained open and transactions have resumed as normal, and others have just been left on hold for the time being. And again, as I say, things have been in recent weeks. We have noticed things starting to pick up on that front. The other point I would mention would be in relation to, as mentioned seen on the PowerPoint slide, which relates to property searches, where properties are being purchased. Certain searches, in particular local authority searches, have been delayed in certain local authorities because of the closures, and the certain departments, property departments or planning departments within certain local authorities have either reduced hours or closed completely due to COVID-19 and the lockdown restrictions, which has had a knock-on effect because the local authority searches have had to be put on hold until the departments reopen. So that has had an impact again on some matters, whereas on others the councils have been operating as normal. So again, it's just on a case-by-case basis, really. And finally, in relation to the land registry, which is more an issue in terms of registrations once matters are completed, again, the land registry isn't immune to the impact of COVID-19, and there has been a noticeable backlog in the types of in the time that it's taken the land registry to deal with applications for registrations. Matters that pre-lockdown and pre-COVID the land registry were able to deal with in days are starting to take 2 weeks for them to deal with, and applications that usually would take a few weeks seem to be taking months. So that has been that's been noticeable as well. So there's certain applications, particularly first registration applications, where a property, for example, is unregistered. Likelihood is that the land registry are going to take a lot longer to deal with those type of applications. So that just needs to be borne in mind as well. So those are the main issues that we've seen in relation to property transactions generally and the impact of COVID. Next, I'll move on to the issue of electronic signatures, which we did have some inquiries about. Again, which is related to COVID-19 as well, because of the difficulties that parties might have in arranging to sign documents. The first point I'd mention, which relates to electronic signatures generally, ultimately electronic signatures are construed quite flexibly, so it could be anything from signing a scanned document, a typed signature, signing on a screen using a stylus or just your finger. So there's different ways of being able to sign a document electronically, and as I say, it has been construed quite flexibly, and obviously as technology progresses, that definition of electronic signature is only likely to be construed even more widely. And the general position is, as far as the law is concerned, is electronic signatures, as long as it can be seen that there's an intention between the parties to enter into an agreement and a contract between each other, then electronic signatures are permitted. But purely from a property perspective, there are additional formalities involved and additional issues that need to be considered, particularly in relation to, for example, property contracts, where the the law is that they do need to be in writing, incorporate all of the terms that have agreed by the parties and signed by the parties as well. For example, just an oral agreement, a verbal agreement won't cut it as far as property contracts are concerned. And an additional point when it comes to property transactions, as mentioned in the slide as well, relates to deeds, because most property transactions will involve a deed in one form or another, particularly transfer deeds, and there are additional formalities involved when entering into transactions where transfer deeds are involved. The main formality here is that the deed needs to be, on the face of it, be stated to be a deed and executed as a deed as well. And the parties, particularly, for example, where an individual is executing the deed, the general rule is that the individual needs to sign in the presence of a witness. Obviously, that can be difficult, and the general position is that the individual signs and the witness witnesses that signature physically at the same time, and also signs the deed. When it comes to electronic signatures, although the general position is that the deed can be signed electronically, but the witness also has to be physically present to validly witness electronic signature as well. So witnessing a signature by a video link, for example, is unlikely to be acceptable. So that needs to be borne in mind. So although deeds can be signed electronically, from a practical point of view, because the witness has to physically be there, it might not necessarily be the best way to deal with the situation, to deal with the problems from a practical point of view. An additional additional issue, and the final point on electronic signatures that we'd mention, it relates to the land registry's requirements, because generally pre-COVID the land registry position was they were strict on their requirements, which is that they require a wet ink signature for all documents that are submitted to the land registry. Since COVID-19, they have slightly relaxed the rules and changed their requirements on electronic signatures, in that they would be permitted, subject to the best practice still being a wet ink signature, and a witness would still need to be physically present when witnessing the signature. What the land registry have said, though, is that they would accept what's known as the Mercury approach when submitting documents for registration. And just to give you a bit of a background, a bit of an explanation of what the Mercury approach is, the best way to kind of give you the explanation is by way of an example. For example, a transfer deed, which is obviously the most common deed that needs to be submitted, entered into and submitted to the land registry. What would have to be done is, the transfer deed would be agreed by the parties, emailed to the client. The final agreed version, for example, of the transfer deed would be sent to the client, as well as the signature page that the client would need to sign. The client can then electronically execute the signature page, sign the signature deed, signature page in the presence of a witness, in accordance with what the rules are, as previously mentioned, physically in the presence of a witness who also needs to sign. And then that can then be emailed back to us along with the agreed version of the document, and those documents can then be submitted to the land registry as electronic documents, to confirm that the parties were in agreement with the documents and they were happy to sign on that basis. So that's a slight relaxation of the land registry rules in terms of signing documents. But other than that, in relation to other documents that don't need to be signed, registered to and sent to the land registry, for example, property contracts, licenses, etc., electronic signatures are permissible, as mentioned originally. So if that seems to be the most practical way forward, and physical wet ink signatures aren't required, then electronic signatures can be used for those. I'll now the next topic is that we'll move on to is rent suspension and rent holidays, and I'll pass back to Adam to cover that.
Thanks, Mo. Just before I move on to that, just to kind of follow up on what Mo said there was a question sent in advance of the session, just to touch on that about witnesses being physically present and not able to witness via video link or Zoom or whatever it may be. I think, as I say, the Law Commission did do a review in 2019 where they were looking at electronic signatures, looking at this sort of thing, and at the time there was an acceptance of electronic signatures, as Hassan's mentioned, but not in relation to any dispositions that need to be registered, and they were also fairly strict in relation to not allowing remote witnessing. Obviously COVID has come along and everybody started to rethink the position. So at the moment it's fairly clear that it isn't permitted. What's our opinion in relation to whether or not that will change? I don't think it will change in the short term. I think at the moment it's something that people are still very cautious about. I don't see it changing in the short term, but I do think it's something that will continue to be considered. Legislation is moving very quickly at the moment. Improvements in technology are happening very quickly, and we're moving from day to day, week to week. So it is something that is being considered by various commissions, various reports. It is being looked into. So I think it will happen. There are already some movements towards doing that, the ability to be able to allow the identification of people remotely, to verify identification for the Land Registry, to be able to carry out formal ID checks for witnessing passport photographs and that sort of thing. So there's a small movement towards allowing remote verification. So it's only a small leap to make that to remote witnessing. But obviously at the moment, they are still standing firm in relation to needing wet signatures and physical witnessing. I don't think we need to go into the details of the risks involved in doing that remotely. I don't think it'll change short term, but I do think it will come in. As I say, if anybody's got any comments on that topic or any thoughts they wish to share or any further questions people want to ask, if it's just our opinions on things, then please do use the chat box. But I'll pick up on rent suspensions and rent holidays. I think this is a topic that's been on a lot of people's lips. It's obviously happened very quickly, and the first thing I'd kind of mention is that I've been pleasantly surprised at just how quickly landlords and tenants have worked collaboratively to discuss rent concessions. The Coronavirus Act 2020 that we'll look back on in times to come very fondly, I'm sure, has moved very quickly to pass legislation, and one of the main things it did was place a moratorium on forfeiture. There was nothing in the Act that obliged landlords to provide rent concessions. Whilst there is a moratorium on enforcement for landlords, enforcing forfeiture for non-payment of rent, the rent still does fall due. So there is no obligation. Whilst people can't enforce, the rent falls due, and once the moratorium expires, which at the moment it is due to expire at the end of this month, 30th of June, but we are fully expecting that to be extended. There's been a recent extension to residential housing evictions until later in August, so I expect this will follow suit, and I'm maybe just jumping a bit further on the slide, but the Corporate Insolvency and Governance Bill is expected to be passed into law later this month as well, and that does interact closely with the Coronavirus Act and moratoriums, and should extend those enforcements even restrictions on enforcement even further. So it's, as I say, it's been pleasantly surprising to see that people have moved really quickly to do that. And what we've seen is that there's been a large amount of rent concessions in relation to rent deferments as opposed to rent holidays. It's important to make sure that any agreement that is put in place is formally documented. We did have a question raised as to whether or not we should just assume that a rent suspension has taken place, and I can understand why people may think that they can't be enforced anyway, so just assume that the rent isn't going to get paid. But I think the general point of advice would always be never assume anything, especially in a legal context. It does need to be put down in writing. And the importance of doing that is that it's just to document what's been agreed so that there's no ambiguity. It may be very simple just to agree that somebody says to a tenant, you don't need to pay for the next 3 months or 6 months or whatever period is agreed. But there are other provisions that need to be documented in the formal written document, which can be done by way of a very simple side letter, 2 to 3 pages worth, less than that essentially if needed, or if it's a bit more complicated, then a formal deed of variation can be entered into. But a side letter can cover off all the main points that need to be considered and documented in relation to how long the concession is in place for, what the concession is, how the repayment works, how that's structured, how long it takes, is interest being charged on that, are there costs to be paid, what's the effect of non-compliance, what if the terms want to be changed again, what if the terms want to be brought to an end, are just a number of factors that can be covered in a very simple side letter that gives that certainty. What I would say is that the main trend in relation to what's been agreed on a repayment schedule side of things is that a deferment period is being agreed, and once that deferment period has come to an end, then usually the deferred amount that has been suspended is then being repaid under a schedule for the residue of the term of the lease. That's often what I'm seeing happening, linked into the rent payment dates under the lease. So that period then is just that amount is added on and covered off to the end of the lease, and that seems to be a fairly well accepted way of doing things, and is part of the standard precedent side letter that is being used by a number of lawyers to link in to whether how HMRC will view these things, which has been asked as a question. But we're going to touch later on the Sippchoice decision. So I think it's prudent to say that we will never know what HMRC are going to say, what they're going to decide. They may say one thing and then decide another, and we'll come on to talk about that. So I can't give any definitive advice as to what HMRC will accept, but I'd be fairly confident in suggesting that at the moment, while landlords can't enforce forfeiture, that HMRC aren't going to be too concerned in relation to what's been agreed in regard to rent concessions. I think where it'll become different is once the enforcement period is over. So I think at the moment, it seems to be widely accepted that that is the kind of market acceptance of how rent concessions will be dealt with, and if those concessions are being agreed with connected tenants, then that should be held up as an arm's length way of doing things. With regards to giving rent holidays, that is a little bit different, and that's not quite as common. I have seen it with some landlords agreeing holidays for, say, charity tenants, or tenants who have severe financial difficulties and are able to show that. And I would just link that to some of the provisions in the Corporate Insolvency and Governance Bill. I'll not touch on them in major detail, but some of the provisions in there do talk about moratoriums and set out some provisions in relation to when the debts are suspended and how landlords can take action. And it does link in to talk about just link in to talk about when the rent falls due, and provisions where whether or not coronavirus has had an actual financial impact on the tenant, and whether or not they would have still had those issues notwithstanding coronavirus. So there are a lot of provisions to kind of look at and determine whether or not it's suitable to agree a rent holiday. I would just say at the moment, rent holidays you need to look at a lot more closely. Without further kind of valuation advice, it's a bit difficult to agree those. But rent concessions, as I say, are fairly widely accepted at the moment and documented in side letters. Just to touch on valuations, as I say, this is a topic that's a bit difficult at the moment. Valuers have been in a tough situation, and it's hard from a SIPP and SAS perspective to look at what the value of rent is at the moment. So with people trying to negotiate new leases, renewal leases, it's difficult to get rent valuations. There's a lot of positions at the moment where leases are being held over. I would strongly recommend that they are addressed very, very quickly. You don't want to have held over leases in place for too long. Tenants can terminate held over leases on 3 months' notice. And if you are looking at negotiating rent holidays, then one trend I have seen is looking at linking a rent holiday into a tenant signing up to a new lease, which is a decent way of doing things, to say, well, we'll give you the rent holiday, but sign up to a new lease, commit to the new lease, and the rent holiday can kick in as a rent-free period connected into the new lease. So at least the landlord is getting the certainty of a longer lease. The valuation situation is difficult. RICS have issued guidance, which I'm sure the majority of people will be aware of. For those that aren't, RICS have proposed valuers to include a material uncertainty clause, which I think just speaks for itself in relation to trying to pin down what valuations are at the moment is very, very difficult. And I still feel it would be very difficult for HMRC to challenge valuations on that basis. But as I've mentioned, and we'll come on to mention, we never quite know what HMRC will seek to do, but we can only try to work within the parameters and guidelines that we're given. And RICS are permitting valuers to insert the material uncertainty clause into valuations that deals with COVID, and basically refers to the valuations being attached less weight on the basis that it's very difficult to value rentals at the moment. If a valuation has that clause in there, then you have to be mindful that it's been prepared in unprecedented circumstances. And whilst RICS have emphasised it doesn't mean that the valuation can't be relied upon, it's more for the sake of clarity and thoroughness that the valuation can't be relied upon with the same certainty that would have been associated with reports carried out prior to COVID-19. So I think it's a case of, with valuations, it's just taking a cautious approach, but I do find that valuers now are getting a little bit more comfortable with the market, that they're starting to see trends appearing, and as I say, I think valuers are getting a bit more comfortable in relation to setting out valuations, even though they may include the uncertainty clause. As I say, if anybody's got any questions that they do want to flag on this, or they want to have a chat around this topic at the end of the webinar, then please flag them up. Conscious that we could talk about a lot of these topics, but we're approaching 10:30, and I do want to make sure that we dedicate sufficient time to discuss the two recent cases, and I think that people are very interested in those. So I'll hand over back to Mahassan to pick up on the Carey decision first and foremost, and then we'll move on to discuss the Sippchoice decision.
Thanks, Adam. So yeah, starting with the Adams and Carey pensions decision, I'll start by giving a bit of background into the case. For those who aren't familiar with the case, it's a recent decision, and the case generally concerns, as mentioned on the slide, an investment by Mr. Adams in storage pods, which he alleges, or he claimed, were missold to him by Carey Pensions. He'd invested in storage pods and was introduced to Carey Pensions by an unregulated introducer, which we refer to as CLP for ease of reference, who were based in Spain. He ultimately, the basis of the facts were that he invested his pension pot of around 50,000 in these storage pods, which in the end it turned out, once he'd invested, turns out they were worth much less than that. And in the hearing, at the court hearing, a valuer had confirmed that the true value of the storage pods was only in the region of around £15,000. So he'd lost quite a bit of his pension pot because of the investment. Mr. Adams' view was that Carey Pensions was in breach of the FCA rulebook by failing to act within what he viewed as the members' best interest in allowing the investment to be made by the SIPP. But Carey Pensions, in response, had argued that it wasn't their responsibility to look into the suitability of the success or failure of any of the investment products. In particular, the facts of the case were that when the contract was entered into by Carey Pensions and Mr. Ed Adams, the pensions, the SIPP operator specifically advised that it was only going to be, they were only going to deal with the investment on an execution only basis, and ultimately it was Mr. Adams' decision as to whether to proceed with the investment. He was aware of the risk involved, and in fact had even signed a declaration to that effect, that he was aware that it was a high risk investment and that Carey was not advising on the suitability of the investment. So those were the basic facts of that case itself. As shown on the slide, the decision of the court was that all the claims that Mr. Adams had made were dismissed one by one. Firstly, that CLP, the introducer, was just that. It was just an introducer and did not advise on the SIPP itself. And secondly, that Carey Pensions didn't breach the FCA rule book, particularly the COBS rule, the Conduct of Business source book rules, which was to act fairly and professionally in accordance with the best interest of the client. Again, this goes back to the specific facts where the contract between the parties was on the basis that the client knew what he was entering into. It clearly set out the responsibility of the client and the SIPP operator, and the court's view was that although the FCA rules were important, they emphasised that the contractual arrangement needs to be borne in mind and would take priority, and any regulations need to be seen through the lens of the contractual arrangement between the parties themselves, rather than just looking at the regulations themselves. And finally, the court held that there was no joint venture between CLP and Carey Pensions in terms of the investment itself. Again, as mentioned, the main ruling, the main impact of the case was that the terms of the contract were pivotal between the parties in terms of the facts of this case itself. Although Mr. Adams did lose a significant chunk of his pension pot, he was aware of the risks involved at this time. The contract made that clear, and indeed at the court hearing itself, Mr. Adams had conceded that he would have proceeded with the investment because of the fact that he did receive a financial inducement from CLP as part of the deal as well, which clearly didn't help his case. That was an important factor that the court considered. One other issue that impact of the ruling that will be relevant as well is seeing the decision in light of the recent Barclay-Burke case as well, because it does seem to contradict on the face of it the decision in Barclay-Burke where it was held that the SIPP provider should have carried out or should be carrying out more due diligence into investments. But it does need to be borne in mind that the Carey Pensions doesn't overrule the Barclay-Burke judgment, and indeed the FCA, since the Carey Pensions case, has been quick to set out that SIPP operators still need to ensure that they assess non-standard investments for suitability. So it doesn't avoid or preclude the need for SIPP operators to carry out the checks that they should be carrying out. The Barclay-Burke case wasn't necessarily a court litigation similar to the Carey Pensions decision. That was a judicial review of a decision of the Financial Ombudsman Service rather than strictly a court decision between the litigation between the client and the SIPP operator. And the main issue to bear in mind or to consider is that when considering the Barclay-Burke case and the Carey Pensions case, is that the cases will be decided on a case-by-case basis, and it might be the case that where there's future litigation on SIPP investments, a court might decide differently depending on the facts of the case. And obviously, like we'd mentioned, the facts of the Carey case leaned more in favour of the SIPP operator because of the fact that they were clear and explicit in the contractual arrangement that they'd had with the client, that they would be that the client was aware of the risk involved. It was made clear to him from the outset, and the court held that they shouldn't be the operators shouldn't have been penalised. Couldn't really have done much more than that. In terms of due diligence, the court was actually the judge did state that the Carey's processes were adequate. Or in this case, what they looked into was whether the investment itself was permissible under HMRC rules, and the judge felt that was suitable and appropriate given those circumstances. But like I say, there may be situations where the circumstances might be slightly different and the case might go the other way. So there's, as mentioned on the slide, there are situations where things might be different. For example, firstly, the contract between the SIPP operator and the client. Here, Carey was very specific in terms of whose responsibilities, what each party's responsibilities were in terms of the investment, and that it wouldn't be advising on the suitability of the investment. And another issue was to do with the client and the member himself. Again, there may be situations where the court would view the client, the member, not to have sufficient knowledge to be able to understand the risk of the investment. Here, the court felt that given the issues and the admission by the client that he would have proceeded with the investment anyway, particularly due to the inducement, that seemed to play a big role in the court's final decision. Again, in a case where that wasn't the case, the court might have decided differently, so that needs to be considered as well. And finally, the nature of the investment itself. Here, there was the issue concerned storage pods. And there wasn't really an indication within the case itself that it was fraudulent or it was a scam. It was an investment that obviously didn't turn out well for the member. It was more of a bad investment, but there wasn't any indication that it was a scam investment, as opposed to the Barclay Burke case, where the investment related to some properties or land or assets in a foreign jurisdiction, which obviously is more of a red flag. So again, that needs to be considered as well. Although, again, based on the facts, sometimes it may be hard to tell the difference between what is a bad investment and what is a fraudulent investment. But again, as mentioned, the issue is that needs to be considered. It will turn on the individual facts of the cases themselves. So unfortunately, the main thing to say really is each case will depend on its individual facts, and unfortunately there isn't a hard and fast rule on the case itself. So as much as we'd like to say that the Carey Pensions decision gives a green light one way or the other, unfortunately it doesn't, and again, everything will have to be considered based on the individual facts of the case of future cases. On a more practical note, for following the Carey Pensions, we've set out here the main things for SIPP operators to bear in mind. Firstly, as mentioned, the court held that the contractual arrangement between the parties, between the SIPP and the clients and the intermediaries, made it explicitly clear as to what responsibilities each party's had. So it is worthwhile reviewing the terms of the contractual arrangements you do have your clients when setting up the SIPP, and particularly the process and the terms of the investments themselves, to make it clear as to who is responsible for assessing the suitability of the investment and placing the onus on the client and the member on that. Getting signed declarations to that effect is helpful, as it was in the case of Carey Pensions as well. The other point is to review any relationships with any intermediaries In Carey Pensions, the intermediary was a Spain-based unregulated company, and obviously there wasn't much action that the member could take against that company because it was unregulated outside of the jurisdiction. Ultimately, when things go wrong from a litigation point of view, obviously the members are going to want to see who they can take action against, and here Carey Pensions was the obvious choice. Obviously, even though the case in this instance the case went in favour of Carey Pensions, from a SIPP operator point of view and administrator point of view, you don't want to be in that position and having to deal with any litigation in the first place. And finally, just going back to Barclay Burke again, as mentioned, it doesn't preclude the decision, doesn't preclude the need to carry out the appropriate due diligence when there are non-standard investments involved as well. So if you do come across investment opportunities that clients are wanting to proceed with, in line with Barclay Burke, you do need to still ensure that any action you do take from a due diligence point of view is set out and documented as much as possible if it does need to be relied on in future. So those are the main takeaways from the case. Adam, is there anything else you wanted to add?
Thanks, Mark, for comprehensive coverage of it. And as I say, I just again encourage anybody, if anybody's got any questions you want to put in the chat box, please use that and we'll pick them up at the end. We should have 10 minutes or so at the end to pick those up. I think whilst, as I say, we do have to be cautious and take each case on its facts, I think it is okay to say this is a welcome result, and it finally gives some guidance on upholding the terms of SIPP providers' contracts, which define the SIPP provider's role and makes it clear that they aren't there to assess the suitability of the investment. So I do think it's a very welcome decision, and I'm sure that people on the call on this webinar who are SIPP providers have been very, very relieved by this, and it will obviously be able to be helpful moving forward for any future claims. One point I would make, we have distinguished it from the Barclay Burke decision for all the reasons that Mahassan's mentioned. One thing I think I would say that was a judicial review. As we say, we've talked about this before. It was a judicial review of a decision made by the Financial Ombudsman Service. There is some commentary warning that the claims management companies that have been jumping all over these and trying to bring these claims may avoid going through the courts, which is where Adams and Carey was. And the courts have taken a very different view, and it's a very different test to be applied rather than the test that the Financial Ombudsman Service applies. So we may still find that the claims management companies turn their attentions through complaints, through that side of things, and they could have very different decisions made that won't necessarily follow the ruling in Adams and Carey. So that's going to be interesting to watch. And I think at the moment we are still waiting for the FCA to come out with comments and guidance relating to this ruling. I think we have to watch and look out for those very carefully to see what they do come out and say, and it's obviously an area of concern. There have been some suggestions made that possible developments and measures that the FCA might look to introduce, and I'll just mention a couple of these again. If anyone's got comments, please flag them up, and it's maybe a conversation we can have further from this webinar. Is maybe the FCA will look to prohibit the acceptance of non-standard assets into SIPPs on an execution-only basis. They may extend the COBS appropriateness rules to apply to all SIPP operators who consider accepting non-standard assets, or they may look to prohibit SIPP operators from accepting business from unregulated introducers. So there's a number of steps the FCA may look to bridge that gap where obviously, I mean, as solicitors, we are often there in a regulated sector and it's easy to be attacked. And as I say, SIPP providers are in the same position in that they are the regulated operators who can easily be attacked to basically take the fall for the unregulated operators in the sector. So it may well be that the FCA looks to tighten things up to bridge that gap. So it will be interesting to see what the FCA's response is to this ruling, and I would just say let's watch it carefully, but still be pleased that this result has come, and that it does, as I say, it is still a very welcome result, that this judgment is placing a lot of emphasis on upholding contractual terms, and for customers and investors taking their own responsibility for their own decisions. And I think that covers enough on Carey for now, but as I say, please do make comments in the chat box if you want to ask any questions to cover at the end. And then we'll move on now more to talk about Sippchoice.
Thanks, Adam. So yes, the final case that we'll be discussing in detail is the Sippchoice case, which is fairly long awaited as well, because it focuses on an issue that I'm aware a lot of SIPP operators have been having to deal with, specifically in relation to in-specie contributions over recent years. By way of background, so the essence of the case related to whether tax relief can be claimed on what's known as in-species contributions, which are contributions that are transferred into a pension scheme that aren't first transferred into cash, specifically and most commonly either property or shares. And in Sippchoice, the facts related to shares specifically. And the essence of the case really related to whether, under the terms of the rules as to what tax relief can be, where tax relief can be granted specifically under Section 188 of the Finance Act 2004, whether these types of in-specie contributions fall within that definition, because the definition simply refers to contributions paid. And so the focus of the upper tribunal's deliberations were on whether in-species contributions fall within that definition. Ultimately, the argument, one of the arguments that Sippchoice raised or mentioned as part of the case, was that the HMRC's own pensions tax manual actually refers to, has a section devoted to in-specie contributions. So surely if HMRC have a section in their own manual related to that, and that it should follow that the tax relief should be permitted for these types of contribution into pension schemes. But within the hearing itself, the HMRC actually went back on their own pensions manual, and effectively argued that the manual was guidance, and it didn't really constitute the law itself, which is what the tribunal ultimately held. The upper tribunal's decision was that in-specie contributions don't qualify for tax relief, and the definition of contributions paid relates only to monetary contributions. And obviously, as mentioned in the slide, the tribunal did accept that this appears to contradict the HMRC's own pensions manual, but their decision was that the manual was simply HMRC's interpretation of the law, and not the law itself, which is an interesting point that they made, and obviously it's going to have more wider implications, particularly on that point. Going forward, in terms of the practical advice and tips that we'd give following the Sippchoice decision, given the fact that the tribunal has held that in-specie contributions don't qualify for tax relief, it's basically a waiting game now to see how what action HMRC decide to take. While the decision is fairly recent, from a practical point of view, it is worthwhile reviewing any in-species contributions and claims that have been made recently, to consider the exposure that SIPP operators have in this area, and to assess any ongoing in-specie contributions that are already in progress, to see if alternative action can be taken to avoid any claims being made. From a wider point of view, the fact that the pensions manual was referred to just as guidance by the tribunal also signifies is an important point to mention as well. So just generally speaking, it's important to review from a SIPP operator and administrator point of view, to review your own internal processes and not necessarily to rely on the pensions manual specifically. There might be future litigation on that point of view. Sippchoice didn't specifically, the case didn't decide what the circumstances are where a scheme places reliance on the guidance, because Sippchoice didn't specifically argue that point. So there may be situations where if a scheme can argue that they did rely on the pensions manual in reaching its final decision in relation to in-specie contributions, it might have been decided differently. But the general position is that it shouldn't be considered the be-all and end-all. And just from a practical point of view, depending on how things go, it may be useful to look into taking preemptive action following the decision as well, which may just be a case of writing to members where in-specie contributions have been made, to just give them a background to what has happened as to the decision, and just so that they're aware, so to minimise the possibility of any kind of claims or complaints being made in future, so our clients are aware of the possibility that HMRC might make a claim in future. I'd also mention that obviously the decision is fairly recent, so there is a possibility of appeal as well to the Court of Appeal. This case itself has taken quite a while to get to the current stage. If there is an appeal to the Court of Appeal, it's likely to take some time as well for the appeal to be heard and the decision to be made. If there is an appeal, the likelihood is, again, the focus will be on the definition of the definition of contributions paid within Section 188 as well, and there's going to be further discussion as to whether the interpretation that the court had made was, whether the upper tribunal had made was correct, on the basis that although the Act doesn't specifically refer to non-cash cash assets, it doesn't specifically exclude non-cash assets either. So if that was the intention in the legislation, there's an argument that if the legislation should have made that clearer. So there is an argument that could change things if an appeal is heard. But for the time being, we obviously have to proceed on the basis of the decision as it is. And that's what we're going to need to work with for the time being, unless and until an appeal is made. Again, Adam, is there anything else you want to add on that one?
Yeah, I've got a few things I would just add. I've noticed there's been a few comments made in the chat, and they're probably link into the points I'll just pick up on. I'm conscious we've not got a massive amount of time, and I'll also give Laura the opportunity to just come in if she's got any litigation angles she wants to talk about. But I feel that we need to do a follow-up on this so we can speak to people afterwards. But there's been a comment from Carey saying, not sure, but aware of a provider who doesn't rely on the pensions tax manual, and yeah, I feel everybody's pain. And there were some very surprising comments by the judge on the tax manual in the Sippchoice case, and how its guidelines can be and have been now challenged by HMRC itself. So it does seem a little bit unfair, which is probably an understatement, to allow HMRC to challenge the guidance in its own pension tax manual. But that is where we are, and that's what we're going to have to deal with. And I would strongly recommend every operator to really look and review processes. And if the pension tax manual is being relied upon as the sole piece of guidance for providing advice and reliance on decisions that are being made, then I think this case highlights the fact that we need to be going further than that. That the strict letter of the law needs to be being researched, applied, and interpreted. So it does seem unfair, but this case, I think, highlights the fact that HMRC are going to potentially sometimes challenge reliance solely on the pensions tax manual. So don't just focus on reviewing processes in relation to in-specie contributions. Look at any other areas whereby the pensions tax manual is being relied upon as the sole source of law. There were questions sent in advance, and they've been flagged again in the chat, flagging up in relation to whether or not we feel this will be extended into SSAS employer contributions. I think the important thing to say, I think, at the moment is that we don't have any guidance on that, but if I had to kind of put my line in the sand, I can't really see how it's going to be any different, and I do think that it is at risk. I think it just needs to be looked at and considered. This whole case centred around a number of factors, looking at different arguments that were raised as to why this wasn't going to be decided the way it has been. But the main factor that it came back to was focusing on it being a non-cash contribution, a non-cash consideration, and that is what this decision has hung on completely, that for it to be valid for the tax relief, it has to be a cash contribution. Therefore, if there are any contributions being made that aren't in cash, then they are going to be liable to be challenged as a result of this, and as a result of this decision. So I do think that it could be extended, and I think it's something that needs to be considered. And as I say, there is a piece around the different tax treatment between SSAS and SIPPs, and there may be some differentials to reach in relation to how that tax is dealt with and how the reliefs are claimed. It's not something we can go into major detail on now, but is something that we can pick up as a separate point if people do want to speak to us about that. And as I say, if people do want to request any further topics that they would like us to cover in a webinar, and if people would like a webinar dedicated to the Sippchoice decision, if people have specific concerns, please do send through any inquiries that you have. I would just also strongly recommend that people do look at what cover they have from an insurance point of view. It's a bit of a morbid topic, but as I say, we need to look at what the fallout is going to be from this, where the claims are potentially going to come from and where they're going to sit. So I would strongly recommend discussions to be had with your PI providers to see if the claims will be covered, and if they are, whether or not we need to be looking at highlighting which claims may come. Picking up on one of the points that's been flagged is how far back will we go? Well, again, strictly speaking, the HMRC can go back 4 years to the relevant tax period. There are some extensions that I won't mention in detail, but I think 4 years is probably the key point to think about. The HMRC, as I'm sure a lot of people are aware, changed the way that the tax reliefs were claimed and the forms that were submitted. So I do think 2016 is the key period to look at. So I would strongly, whilst they can go back further, I would strongly recommend that reviews are undertaken of any business that's been done that may fall foul of this, going back to 2016. That'd be my strong advice. Just picking up, there's a few other, as I say, a few other chats that have questions that have come in. I'll just have a look at what has come in, and just wondered if, Laura, did you have anything you did want to add from a litigation angle whilst I just collate the questions that have come in?
Hi, sorry, I was on mute then. Sorry. No, I don't have anything to add. No, I think you've responded to everything. And obviously, I'm here from a property perspective, so it's more of a kind of trusts answers, which I think you've covered. I don't really have anything to add. Sorry.
Thanks, Laura. There's been a question asked: is the Carey's case being appealed? We don't know yet, but there's a very, very strong chance that it will. It does seem to be the general feeling that it will be appealed. So yeah, that obviously we need to watch this space on that one, but the intention seems to be that the case will be appealed. So we'll have to wait and see what comes of that, and whether the appeal is successful or not. But as I mentioned earlier, I do think that whilst it is a welcome decision, and even in the appeal there'll be factors to be considered, I still think it needs to be treated with caution, as Hassan mentioned as well, just because each one will turn very much on facts of each individual case, and as I say, that there is the opportunity for people to still make the claims to the Financial Ombudsman Service. So I do think it's a welcome decision, but one to treat with caution, whether or not it is appealed, and whatever the result of the appeal is. Another question that's come in here: does the panel accept that HMRC and the FCA have prepared the pensions tax manual and the handbook with significant amount of due diligence on their own parts? If so, do we accept that they have failed if they're now renouncing their own guidance on the basis of admitting it's deficient? Well, it's hard to argue with those comments, and I do think that it is very, very surprising, as I mentioned, that the comments that the judge made, and that HMRC are being permitted to raise challenges on guidance that's been relied upon by operators due to their own manual. But as I say, I think they would consistently say that the manual is guidance and it's not a primary source of law, and it does sound a little bit of a get out clause, but I think that, and it's very, very frustrating, and I share people's frustrations with it, as that's what HMRC have done here. But I think the main takeaway with this is to say that the pensions tax manual is guidance only and cannot be relied upon, and whether it ever could be, I think we have to accept that moving forward it is not sufficient to rely on it solely as a piece of legislation. It is guidance only, and I would strongly recommend that the letter of the law is interpreted, the relevant sections of the relevant legislation, whether it be the Finance Act, whatever it may be, needs to be considered in further detail in relation to any decisions that are made with regards to investments and whatever it may be. So that would be my main kind of comment as a takeaway, that the pensions tax manual is guidance only, and this has now been firmed up if it wasn't already known. Yeah, there's been a comment. I'm not sure if it's a question or a comment, but as I say, I think the general gist of the comment that's come in is that there are these claims management firms, and that they are coming after people. They do as a solicitors. It is, if you're in a regulated sector, it's often easier to go for the people that are regulated the strictest, and to go for the people that are the best insured, and that is unfortunately the way the world seems to be these days. And I can't say that I agree with it, but it is the world that we live in, and unfortunately this is why steps need to be taken to be put in place, and this is where processes change, legislation amends these things, so that any kind of processes that are in place have to be looked at in relation to protecting against this sort of thing. So we have to just live with the world that we're in, and the claims management companies are just looking for any kind of insinuation that somebody did something wrong. But I am hoping that the ruling in the Carey case, subject to any appeal, is going to be very important. As I say, it was very surprising how far the judge went in the comments of really putting that onus onto the individual, and that's one of my biggest important takeaways from this. That I think it's something within the legal sector that we often look at and think, well, it's very easy for somebody to turn around in the future and say, well, I wasn't advised of that, it's somebody else's fault, when at the end of the day, people are responsible for their own choices and decisions. So I think it was very refreshing that the judge in the Carey case went as far as effectively to say that. And again, as Mo's mentioned, it does turn on the facts of that particular case, but that, I'm hoping, will be a very important takeaway, and hopefully will be comments that will be followed in any appeal or any other future claims or cases that come to in front of the court or the Financial Ombudsman Service. I can't see any other questions in the chat, and I'm conscious that with 5 minutes over our allotted time, it's kind of, there's a glut of legislation and cases and COVID has come along, and it's a very, very challenging time that we're working with at the moment. So, as I say, if anybody does have any further questions that they do want to raise, then hopefully everybody will have our contact details, but I'm sure they'll be followed up and circulated if they don't come up on the screen, so that people can get in touch. And please do send us through any details of any further topics or webinars or anything that people want us to cover, and if they want us to go into any further detail of any of the points that we've raised, as I say, we can dedicate specific webinars to any points that we feel need further consideration. So on the basis that it looks like the questions are coming to a close, and I think people are having to shoot off to the next virtual meeting that they've got in the diaries, I will just end by saying thank you to Laura for joining and being on hand for any complicated litigation questions that may have arisen. Thanks very much to Mahassan for a very comprehensive webinar that he's provided today. Good information and some good practical hints and tips. And thank you to everybody for joining us, and we will see you again on the next webinar. Thank you.